In the age of hyper-regulation and aggressive enforcement by agencies like the Enforcement Directorate, even legitimate cash transactions can land you in the crosshairs of the Prevention of Money Laundering Act 2002, that is the PMLA. Whether you are a lawyer advising a client or a business owner handling large sums of cash, this video will guide you on how to legally structure high-value cash transactions, reduce regulatory risk, and stay miles away from the PMLA trouble. Let's be clear, under PMLA, it is not just about whether a transaction is illegal. It's about whether it can be perceived as a part of the money laundering process. And here is the catch. Even if you are not involved in a predicate offense, high-value cash dealings can draw unnecessary suspicion. So structuring these transactions correctly is not just compliance, it is self-protection. Here are key legal thresholds you must always keep in mind. Under Section 12 of the PMLA, reporting entities like banks, NBFCs, and intermediaries must maintain records of all cash transactions exceeding 10 lakhs. Income Tax Act Section 269 ST prohibits receiving 2 lakhs or more in cash from a person in a single day or in respect of a single transaction. Cash deposits of 10 lakhs or more in a financial year trigger reporting under Form 61A to the Income Tax Department. If your business is already under scrutiny for a predicate offense, say under the BNS, NDPS, or the Companies Act, then any large cash transaction can be linked as proceeds of crime under Section 3 of the PMLA. Now let's talk solutions. How do you legally structure high-value cash transactions? The very first step, avoid fragmentation. Don't split a 10 lakh transaction into 1.9 lakh chunks to avoid 269 ST or banking thresholds. This is called structuring and can itself be seen as a red flag under the PMLA. Use banking channels. For high-value payments, always route through RTGS, NEFT, UPI, or check. You not only maintain traceability, but also get immunity from any suspicion of money laundering. Maintain documentation. Create an audit trail. Maintain invoices, payment receipts, PAN details of counterparties, and reasons for any unusual cash usage. Documentation is your first defense. Involve legal advisors early. Ensure your in-house or external counsel vets any large cash transactions beforehand, especially if you are in sectors like the real estate, jewelry, or hospitality. KYC and source of funds. Always verify source of funds of your counterparties, especially in cash-heavy industries. If you are receiving high-value cash, get a declaration and ID proof of the payer. Cash-intensive sectors require to deal with it more cautiously. For real estate firms, avoid accepting advance cash for property bookings. Use escrow mechanisms and ensure all payments are bank routed. For export-import businesses, ensure FEMA compliance and declare high-value transactions through RBI authorized channels. For NGOs and trusts, disclose cash donations transparently in your audited reports and register under FCRA if receiving foreign funds. Lastly, invest in compliance, automation, tools, and train your staff on anti-money laundering red flags. Because in the eyes of law, ignorance is no excuse and negligence is a liability. So the next time you or your client are dealing with high-value cash, pause, plan, and protect. This is Dr. Arjun Chowdhury, advocate, signing off. Jai Hind.